this dialogue intends to open the streams of communication between Romanian and Swedish arbitration communities, particularly because both of these communities are extremely important in shaping up arbitration. And it would be to no surprise that Sweden is at the heart of the development of international law, particularly because of its position in the relationship with Soviet Union, former Soviet Union, and also Western Europe. From a geopolitical standpoint, Sweden's role has been cemented during the Cold War, as has come up during the USSR and the United States bilateral treaties signed in 1976. And I hope that the Swedish embassy could extend this analysis and discuss a little bit of the geopolitical role of Sweden in resolving disputes, so to say. And we're also honored to have Lynn Berman, the Deputy Secretary of the SEC's Secretariat, who hopefully can share some of her experiences in terms of presenting the role and what the Arbitration Institute has done over the course of 30 years to establish itself in resolving specialized issues that have come up in Eastern Europe as specialized for former Soviet Union countries, but also in Southeastern Europe. But to talk about the past would only get us so far. We're actually at a point where a lot of things are changing, and they're changing at a dramatic speed, and we can witness that in Bucharest, so to speak. We're faced with monumental challenges in the upcoming years, and one needs to go only a few blocks to witness how vibrant the dialogue is in Romania, but also how important three pillars of modern society is the rule of law, accountability, and efficiency, and how important these three pillars are to the economic climate and to the development of a steady body of case law. Now, the framework for resolving disputes affects everyone, some directly, others indirectly. And how Romania has managed somewhat successfully, somewhat unsuccessfully to adapt to these challenges, actually quite important for both for Romanian practitioners, but also for Swedish practitioners to hear. Now, a new Swedish initiative seeks for sustainable development in business organizations, and this is what the Swedish Embassy has promoted. Now, arbitration might actually, with an eye of looking at the future, arbitration may play a critical role in ensuring sustainable development. Companies do not think of the risk of litigation unless, unfortunately, it is too late. But that point of too late comes up with the risk of bankruptcy, the loss of employees, the environmental challenges. It's exactly the same issues that perplex a lot of the people who are out in the streets today. And the results of the arbitration that comes out in the form of the final award is nearly universally enforced in over 150 countries of the New York Convention, with a very limited avenue of a challenge. And that point is that award has considerable significance for a company that's looking for sustainable ways of managing its risk. And hopefully the Swedish Embassy might explore those avenues as well, both now but also for the future. Now, this dialogue, of course, examines arbitration as a process, not just within the company framework. And in that point, arbitration has its allure for commercial arbitration has become basically the most practical way of resolving disputes. Its popularity has come at a high price, which comes with the increasing cost, and that's exactly what we're here to discuss with the distinguished panels. And those costs have been materialized mostly in increase in the cost of representation, and hopefully we can discuss those issues as well. Why does arbitrating in Paris or in Stockholm or in Vienna has become so costly, and where do those costs come from? Now, the rapid rise in arbitration has prompted a lot of changes, and the SEC and a lot of arbitral institutes have kept up with those changes. But the challenge of these increased costs are truly real. The survey concluded by the Charter of Institute of Arbitrators have provided a toolkit. They've discussed a little bit of a toolkit. And in terms of the toolkit, we can basically assess that there are quite a lot of tools already out there. And one of the points of this dialogue that we hope to explore is if there are any gaps, where those gaps are, and what can we do in order to satisfy those gaps, in order to ask for particular tools to be developed or for the arbitration rules to reflect those needs. What we've done as a starting point is to divide the entire topic in 5 stages, looking from basically the beginning of where the arbitration starts to the end. And a lot of the tools that are being that have been advanced, they actually come in at one point or one stage than the other, one stage over another. So having divided this entire spectrum in 5 different stages, the drafting of the clause, commencement of arbitral proceedings, evidentiary issues, the hearing, and enforcement issues, gives us an opportunity to share the gaps and to learn more about the experiences, so to say. At the end of the sessions, we'll have a few questions and answers, but the format of the debate is going to be such that there will be an affirmative presentation that would be between 7 to 10 minutes, and then there will be a response from another member of the panel, and all for the entire discussion to range between 12 to 15 minutes at the most. And at the end of the session, there will be a question and answer session. We would want to point out that this whole entire session is actually recorded, but it will be only recorded during affirmative presentations. And with that, I would like to also mention that there was a little bit of a small change in plans. Unfortunately, Dan Engstrom, the managing partner of SALC, was not able to attend, and instead we have Michael Beckstead. He'll be presenting instead of Dan Engstrom, and we're actually very lucky to have Mr. Beckstead here because he is a legendary figure in Swedish arbitration. He actually has served on the board of directors of the SEC Arbitration Institute. He served as counsel with Skandia and for 20 years. At one point the position of general counsel, and in addition to his arbitration experience, Mr. Beckstead has also successfully represented clients before the European Court of Human Rights and the European Court of First Instance, and he's also a leading expert in international law as related to cultural heritage. So I hope that would not create too much problems in terms of making the substitution. So with that, I would like to introduce quickly the Swedish Embassy, and then follow that, we'll start with the panel discussion.
Thank you. My colleague Soren Suchu and I are happy to be invited to this, as representatives of the Swedish Embassy, to this dialogue on how to control costs in international arbitration. And of course, we are happy to participate and answer any questions during this afternoon, if you have any. The aim with international arbitration is to resolve business disputes, to find a solution that is sustainable and cost-effective without losing your business relation. I think that must be it's war, right? Arbitration is the only practical method for resolving cross-border disputes arising from business contracts. It's the most preferred method for solving business disputes in general. The more complex our world and our business transactions get, the more lengthy and costly it is to find solutions. At today's seminar, we will learn more about the Swedish Arbitration Act and the Stockholm Chamber of Commerce arbitration rules. And I'm very happy to learn that they have been unofficially translated into Romanian. I think this makes the whole difference. Sweden and Romania have a long history of doing business. I think the first Swedish companies were here before the Second World War, or even before that. So I think we should continue building our business relations based on this long and trustful relationship. As you probably know, in my country, Sweden, business culture is based on trust. a handshake is often the only sign that a business deal has been settled. Maybe this is not possible, not even recommendable, when doing international business with cross-border transactions today. I would like to mention a few words that I think you can think about when thinking about Swedish business culture, and that is social responsibility, environment responsibility, good labor relations and standards, safe working places, and a zero tolerance of corruption have for many decades been important parts. In Romania, I think there are now 130 some companies present. And as you mentioned before, in May last year, a number of companies, together with the embassy, decided to form Swedish Sustainable Business in Romania, a corporate social responsibility platform. The common principles of this Swedish Sustainable Business in Romania is human rights, good labor standards, environment, and of course, to combat corruption and to get to know each other within this group so that you can discuss corruption cases and how to deal with it. I think Romanian business culture is not much more different than the Swedish, as I understand from the Swedish business community here. Maybe the bureaucracy is heavy with red tape, and court trials can be lengthy when trying to solve business disputes. Finally, I would like to mention that there is a bilateral investment protection agreement between Romania and Sweden that entered into force 2003, before Romania became a member of the EU. This agreement is about promotion and reciprocal protection of investment. In this agreement, you can find references to international arbitration as to resolve disputes that cannot be settled amicably. During my 1.5 years here, I'm looking at Soren if you have any other information, only one company has been using this agreement in a business dispute. So I hope this seminar will be successful, and I look forward to learn a lot during this afternoon. So thank you.